Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible Ted Baum, a New York construction lien law guru. Today's webinar topic is getting paid faster with liens, bonds, and contracts. So without further ado, I'd like to introduce the fabulous Ted Baum.
Well, I hope I live up to the billing of incredible and fabulous. I kind of doubt it, but the good news is that I've practiced in the area of construction law since I started practicing in 1991, and I've dealt with liens, bonds, and construction issues since that time. It's been the backbone of my practice during all that time. And although I'm located in Rochester, New York, I've done work throughout the state. I've handled construction matters in about more than half of the 62 counties in New York. So here's our first screen on the webinar. As you'll see, you have the opportunity to ask some questions in the chat box, and I can address those at the end. You'll see your instructions on the screen there for that, and I'll do my best to answer all the questions. Sometimes they're a little too fact specific or a little too much to try and get an answer to. Also keep in mind as we go through this, we've got a condensed period of time to address this. I'll go through some of these concepts somewhat quickly and somewhat superficially just because of the limitations of time. The topic today, of course, is how to get paid faster with liens, bonds, and contracts. So there are three kinds of liens in New York. Technically, there's only two, but I've created a third category because there are some important distinctions. The first is the public improvement lien. This is something that does not exist in a lot of states, and I should mention at this point that my discussion focuses exclusively on New York law. Do not assume that anything I tell you today applies in any other jurisdiction because it likely doesn't. There are lien laws in every state of the United States, and they're all a little bit different. And I'll talk about some of those distinctions as we go through today. The other important thing to keep in mind, I'm about to talk about public improvement liens, but that's exclusively for New York public improvements, and I'm distinguishing that from, for example, federal projects, because there are no lien rights on federal projects, whether they're in New York or elsewhere. But within New York has created, unlike a lot of states, has created an opportunity for folks to file public improvement liens. And really what you're doing is you're not liening the property in that instance, you're liening the public fund of money that's been set aside for the improvement, because all public projects will have a dedicated fund that's for that project, and that's what you're actually liening against. Important to understand a couple of distinctions about that, and I'll be going through these in a moment. But the next category of liens are private commercial liens. The lien law doesn't use that term commercial. I'm using that term to refer to a project that's not residential. And when I say not residential, I mean it's defined in the lien law, 2 to 3 family is considered residential, 2 to 3 family or less as considered not as considered residential, and just about anything else is commercial. So you may be working on, for example, an apartment building. That would be, if it's new construction, that would be considered a commercial project, not a residential project, even though what is being built is residential. And then the third category, which again is not technically a separate one, but there are separate rules that apply to private residential liens, and those have some important distinctions. And if we can go to the next slide, I'll talk about some of those. So public improvements, these are really effective tools if you haven't been paid. It's important to understand that these are available only to subcontractors and tiers below them, and not to general contractors. And the whole purpose for this will make that the reason for that clear. And that's because when a subcontractor files a public improvement lien, the public owner is required by law to withhold 1.5 times the amount of that lien. So, for example, a $10,000 lien will result in a withholding of $15,000, or a $100,000 lien will result in withholding of $150,000. So you can see that that becomes an effective tool. Who's it withheld from? It's withheld from the general contractor, and it'll continue to be withheld until that general contractor either obtains the discharge of the lien or bonds it off, which is certainly common in public jobs. Usually pretty easy for the general contractor to get bonds to bond off the lien, because those jobs are also required to have payment bonds, and a surety doesn't face any different exposure to a lien bond than it does to a payment bond. So those are routinely issued, but they do represent an expense to the contractor. And of course, until that lien discharge bond is posted, the amounts are continue to be withheld. Now, I'll make an observation here that as a practical matter, there's not uniformity of understanding of these rules among New York State public owners. And by that, I mean, if you're dealing with a project for the state of New York, and the lien that gets filed is filed with the controller, the New York State controller, they are very sophisticated about liens. They understand how they work. They understand how long they live. They understand what's required to get rid of them. If you're dealing with a small municipality, for example, or a school district that doesn't do a lot of construction work, they may not be as sophisticated in those rules. They may not understand even the withholding obligation. And sometimes it's necessary to educate them as to their obligations under the law. Even the attorneys for these towns, they are often dealing with issues that municipalities face in other arenas and don't know much about construction. So that is something I've run into time and again. The other thing is important to understand is that your lien right is only as effective as there is money left on the job. So, and that's true for any job, whether it's private or public. Your lien right only extends to the amount that is available to be paid to the contractor or those above you if you're at a lower tier, or that will be paid at some future date. So that's important to understand. If the owner has paid out everything before the lien is filed, the lien is not effective. On the other hand, if the owner believes it doesn't owe the contractor anything, the lien is arguably ineffective, but that's a difficult thing to establish. We go to the next slide, please. Oh, I'm sorry, before we move on, I'll talk about on this slide. The timing for the notice of lien on a public improvement it's 30 days from the date of completion and acceptance. Now, that's easier said than understood because it's often not clear what the date of completion and acceptance is. My rule of thumb is if the owner's still holding money, you probably are going to have an effective lien. But a caveat to that is sometimes there are long periods of time where owners are holding retention, maybe up to a year, and they may or may not honor the lien that's filed more than 30 days after completion and acceptance. There does exist a certificate of completion and acceptance, but I will tell you that even though that animal exists, I have very rarely seen such a document that clearly establishes the date of completion and acceptance. I've seen items that are similar, but they're different, such as notice of beneficial occupancy, things of that nature, substantial completion certificates. They're similar, they're not exactly the same, so it's a little bit elusive. Next slide, please. So as I mentioned earlier, there are a lot of the New York State agencies, Dormitory Authority of the State of New York, State University Construction Fund, New York State Department of Transportation. You're going to be dealing with people who are very knowledgeable and sophisticated about liens, but if you're dealing with a small municipality or a rural school district that doesn't do a lot of construction work, it's a very different set of circumstances, and you may find yourself, or your lawyer may find himself or herself educating those who need to be educated about the rules. Next slide, please. So let's move on now to a discussion of private commercial liens. And let me say here, one of the questions that often crops up because of how things are different in other jurisdictions is, what about the pre-lien notice of furnishing? That does not exist in New York. So I know in other jurisdictions, before you can have a lien right, you must have filed a notice of furnishing or some other document that gets filed with a similar concept at the very beginning of the job. That just doesn't exist in New York. Your lien rights are as defined by the New York statute, which really talks in terms of the timing mechanisms. Okay, so private commercial liens, why are they effective? They don't have the same level of effectiveness because there isn't the same requirement of a statutory requirement of the withholding of a specific amount. That said, I can't remember when I've seen a construction contract between an owner and contractor where the owner didn't have the right to withhold money in the event that liens were filed. And that's just good common sense, because if the lien is not gotten rid of, the owner is going to be stuck with the problem at the end of the job. So typically, there's going to be a contract provision which requires the general contractor to get rid of the liens. And again, this can be done by obtaining a discharge either through court or getting the lienor to agree to file a discharge, or by getting a bond. Now, getting a bond may not be as easy on a private commercial job if the job itself has not been bonded, because private jobs are not required by law to be bonded, only by contract. So it's not uncommon for there not to be a bonding requirement in a private job. And I will tell you that lately what I have seen is that almost no surety is willing, unless they have a very good relationship with an existing account. They're typically not willing to provide a lien discharge bond unless they are collateralized 100%. In other words, given 100% of the amount of the lien bond. And by the way, the lien bond by law should be 110%. That's an oddity, even on public jobs, because as as you heard earlier, the owner is entitled to withhold 150%, and yet the lien bond only has to be for 110%. Going back to the private jobs, where there's a lending bank, that bank may or may not be aggressive about the liens. Again, there may be a level of sophistication issue here about how knowledgeable the bank is about liens. I know they don't like them generally. And I talked about the effectiveness where the job is bonded or not bonded. With respect to timing, again, no pre-lien notice for a private improvement lien. The timing provision, though, is very, very different from the public lien and is measured from the date that the lienor last supplied labor or last supplied material. And the time period is 8 months. Important distinction. Let's go to the next slide, please. I think this is where it's covered. Important distinction for the private residential lien is that instead of 8 months, the time limitation there is 4 months. On that private residential, I will tell you, if someone filed a mechanics lien on my residence after having done work there and I disputed the amount due, I wouldn't be too concerned myself about the lien because I don't have plans to go anywhere soon. So I wouldn't be frightened about the lien. If there's a mortgage, that may or may not create an issue for the party. I haven't seen mortgage lenders on private residential mortgages come down very hard on parties about having liens on, but where it's commercial, that tends to be a little bit more attention paid to it. The issue of willful exaggeration is important in the discussion of liens. That's what's only available in a lien foreclosure action. The assertion that a lien has been willfully exaggerated, and there's some serious ramifications for that. It's also important to keep in mind that in the event of a foreclosure action, there are a lot of important items that have to be pled, as we lawyers say, in other words, written in the complaint, and a lot of things that have to be proved that go beyond ordinary contract issues. And that's where a lot of lawyers who don't do a lot of construction work can fail or get into trouble, is where they don't have the proper pleading or prove the proper items in their foreclosure action. Next slide, please. This is the willful exaggeration issue. Do not ever exaggerate your lien. Now, exaggeration has a very specific meaning, and that is where you have a firm understanding of what is or is not due, and you claim well in excess of that without any basis at all. Then you have willfully exaggerated. If, however, you claim you're owed, say, $100,000, and the owner or contractor says, no, you're only owed $80,000, but you have a legitimate basis to claim the 100, there's just a dispute about it, that's not exaggeration. The remedies for exaggeration include cancellation of the lien and the obligation to pay for the fees for discharge, and also potentially canceling your contract right to those funds. But again, this is only available where there's an actual lien foreclosure action filed. Someone can't just claim willful exaggeration without the existence of a foreclosure action. Next slide, please. As I mentioned earlier, if you've got an established contractor with a strong surety relationship with respect to bonds now, the assertion of a payment bond claim is not going to be super effective in getting you paid right away. If there's a series of payment bond claims on a particular job, that's what's going to get a surety nervous. But an isolated payment bond claim is pretty routine, and the defense is going to be tendered, as the surety will say, to its bond principal. Does a lawsuit change the complexion of that? It can, depending on the nature of the claims that are asserted in the lawsuit, the size of the claim in relation to the bond, and the financial strength of the bond principal. Things can happen to a contractor, and they may not be as financially strong at the time the lawsuit is filed versus when the lien was filed. One thing that's important to pay attention to, and that is that your rights under a bond on a public job are defined with a minimum set of standards by the New York State finance law, but the surety can give you more generous terms on its bond. And so whereas, for example, if you're not in direct contract with the principal, say you're a subcontractor to a subcontractor asserting a claim on the general contractor's payment bond, you're required to provide a notice of your claim on a public improvement within 120 days of the last labor or material. If you're directly in contract with the bond principal, you don't have to provide that notice. But if the bond doesn't provide for that notice, you may not be required to provide it. So it's important to pay attention to what the actual bond looks at. By the way, really important, you should make a routine part of your upfront relationship on a job before any problems arise. If there's a bond, get a copy of it and just stick it in your file before things get ugly, because when you need it, you're going to be scrambling to understand who the notice goes to, what the notice must say, and so forth. Next slide, please. So with respect to liens, as I talked about earlier, on the public job, keep in mind, these are only available to those tiers below the general contractor. The effectiveness has to do with the owner's obligation to withhold, but only effective to the extent money still remains on the job. Next slide, please. And then one last thing I just wanted to mention, this is a topic that's getting more and more attention by the courts and asserted more frequently, and that's the New York Prompt Pay Act. Does not apply to public work, only applies to private jobs over 150, although I think that level may have been increased to 200. There's some interesting timing requirements. The general contractor or the owner, depending on who's asserting this claim, only has 12 days to reject or dispute an invoice, which is not a lot of time. And there's a really punitive interest provision. It's 1% per month, as opposed to 9%, which is hefty enough under any other kind of contract claim in New York. Another interesting facet of this law is that it forbids the application of another state's law or dispute resolution in another state in the contract. It makes those illegal. But I saw a recent case where the court decided it was okay to apply a different state's law, and the fact that that state honors pay if paid, which New York does not. But that was a snow plowing contract, so while it's an improvement, arguably falls under this law. That wasn't argued in the case apparently, and so it's a little unclear whether it would have application in a clear construction case. And next slide, please. And that brings us to the end. I think I'm a couple minutes over, so I apologize for that. But if there
Please
are
don't apologize. That was great. I appreciate it. You definitely lived up to the hype, by the way. I appreciate you. Okay, so we do have a couple of questions that came through. Some of them I think you did touch upon,
Okay.
but I'm guessing they need a little bit of clarification. It says, who receives the lien upon funds? And then
Great
what are you
question.
actually liening?
Okay, so that's a terrific question. The lien upon the law says tells you exactly who that is, but of course, as always, that's sometimes harder to determine in practicality. The law says that a lien upon a public improvement against the funds must be filed with the chief financial officer for the public owner and the head of the department in charge of the construction. So that second part is often very hard to determine. Usually the chief financial officer is somewhat easy, the city controller, for example, but the head of the department in charge of the construction, you have to know which department is running the job. So it's a dual filing requirement. It must be filed in both with the chief financial officer and the head of the department in charge of the construction.
And I think this is a follow-up question that they popped up for it. What's the filing deadline for the lien upon funds?
That is that 30 days from completion and acceptance of the work. Again, that's going to be a date that's really hard to determine in some cases. Bottom line is, don't wait till the end of the job. But the good news is, even if you were the site work person who did your work 2 years ago, if the job still hasn't been completed in acceptance, you still have a lien right where you wouldn't on a private job. But it is that 30 days from completion and acceptance.
Okay, thank you. Another question that came through, what if there isn't a bond on the project and the GC was paid in full?
So the existence of whether or not there was a bond, first of all, there will be a bond on every public job because that's required by law. But so we're talking about a private improvement job where the bond is only required by contract. Whether a bond is or is not required has no bearing on lien rights, or for that matter, contract rights. It's just a tool to get paid. So the fact that there was no bond doesn't change the timing of the filing of the lien or your rights under the lien law.
Okay. And then this is a two-part question that just popped up. Do you have to be licensed in order to lien in New York? And then do you have to have your business set up in New York at a physical location?
Okay, two great questions. I'll take the first one first. The licensure requirement, the answer is it depends on where you are and what kind of work you're doing. New York doesn't have a general licensing requirement for contractors, but there is an exception to that, which is in the Metro New York area. You have to be licensed for home improvement projects. And there are cases that say where you are not licensed, you do not have a lien right. There are other cases that have some level of disagreement with that, but that's I've seen that enforced a number of times in a number of different cases. The second question is, do you have to have a physical location within the state? The answer to that is you do not need a physical location within the state to assert any lien rights or bond rights or contract rights. However, in order to avail yourself of the New York State courts, in other words, file a lawsuit, you must have the authority to do business within the state. And if you don't, that's a basis to knock your claim out. Having said that, what I have seen more often than not is that the entity is allowed to fix that problem even after filing suit. In other words, get registered after the fact and just catch up on any fees they have to pay to the state.
Okay, wonderful. Thank you so much for that clarification. I do believe that that's all the questions that have come through. If you do think of a question that wasn't addressed, please feel free to reach out and I'll be sure to answer those questions as soon as possible for you. Let me get to the next one. Here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. Go ahead and scan that QR code to access these incredible resources. There's wonderful project information sheets. Like Ted was saying, when you guys are first starting a contract, if there is a bond, try to get those documents up front. It's just going to help you know what the expectations are and what the rules for that particular job on how to file your bond claim and whatnot. And what Ted was saying is each state has its own unique lien laws. So New York is very different in certain aspects, but remember each state has its own lien laws, own set of deadlines, own set of documents. So please feel free to check out on our site. We can show you exactly what it is that you're needing to do in nearby states to keep yourselves protected. All right. The next webinar we have with Ted is going to be February 11th. What happens after I record my lien and how do I get paid? So please go feel free to register at sunraynotice.com/education for free. We'd love to be able to see you guys there. All right, and if you don't mind, take a moment. It takes about a minute of your time. Scan this QR code. Give us a review on Google. We really like to hear the feedback you guys have for us. It always helps us improve and better ourselves, so we really appreciate that. All right. That is all we have for you guys today. Again, thank you, Ted. You really are incredible, and you definitely lived up to that hype. Thank you to everyone who did attend today. We hope to see you guys at our next webinar. I hope you all have a beautiful and wonderful sunny day. Thanks again. Bye, everyone.